that will be taken as granted, because, I mean, I just want to be clear so we are guided appropriately. I'm sorry?
We want to take the witness first.
Very well. Bible. I, Johnson Asiedu Nkatia,
Do in the name of Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give
that the evidence I shall give
in this case
shall
be the truth,
be the truth, the whole truth,
and nothing but the truth.
and nothing but the
So help me
truth.
God.
So help me God.
Lost SOD in English.
My lords, I believe the procedure, since it's not expressly provided in CI 99, I believe the procedure is as provided in CI 47 in respect of witness statements being. I just needed to be clear, maybe. So we're getting a copy of the file copy of the witness statement. Yes, so that we can, what we have filed. I'm sorry.
And then we adapt it as his evidence in chief, and then cross-examination will follow.
Yes.
Just so that we are not caught by time, we have objections to certain parts of the witness statement, and we would apply to the court to have those parts struck out as not relevant nor based on the pleadings of the petitioner, or otherwise scandalous and prejudices unfairly.
Mr. Kotuampa, the witness is here to identify the witness statement, so just wait.
No, I'm just serving the court with notice, because it is sometimes assumed that if you keep quiet and you tender it in, then you are caught.
Mr. Kotuampa, we don't tender evidence. So when it comes to the box and he relies on it, after he has been sworn, he relies on it, then it becomes evidence. Then if you have any objection, you can raise it. Yes. As it is now, it is not evidence before us.
Please give your full name to the court.
I'm Johnson Asiedu Nkatia.
And you have filed a witness statement on behalf of the petitioner.
Yes, my lord.
Can you identify what the deputy registrar has made available to you and confirm that it is the witness statement that you have filed?
Yes, my lord. This is a witness statement that I have filed.
My lord, we wish to tender that witness statement, or it's taken, it's adopted by the, yeah, very well, very well. That's the procedure.
Yes, my lords, as I've said, we are objecting to certain paragraphs or parts of some of the paragraphs in the witness statement of Mr. Johnson Asiedu Nketia on the ground one, that they are not based on the pleadings. 2, they tend to unduly prejudice some of the parties to this suit and are scandalous, and accordingly we would pray that those paragraphs or parts of those paragraphs be struck out as such. Yes.
The third grounds of objection. The first one was that it was not based on the pleadings.
Yes.
And the second one, unduly prejudicial. And scandalous. Yes. Yes. What is the third one? The third ground.
Is it scandalous?
Yes.
Oh, okay.
My lords, I believe that it's well established that a party's evidence.
But could you identify the paragraphs first?
Very well, very well. My lords, we are referring to paragraphs 21, No, I have it. Yes, Valerie.
You have set out 3 grounds. Which of those 3 grounds is applicable to paragraph 21? What I'm asking you to do is tell us your ground of objection within the 3 before you start your arguments, so we can follow you.
Hold on. My lady, paragraph My lady, paragraph 21 is not pleaded. There's nothing in the pleadings to that effect. Yes. The pleadings, this evidence that they're seeking to lead is not borne out by the pleadings, my lady.
It's not based on.
It's not based on.
Okay.
My lords, we also object to.
Do you mean the reference to the website in that paragraph?
It says moving and changing and subsequently deleted. These are very material facts. If they sought to rely upon it, they should have pleaded it.
Yes.
My lords, we also wish to take objection to paragraphs 6 and 7 as completely out of place. Out of place in the evidence in chief.
What does that mean? What does being out of place?
It's not admissible, my lord, because yes, because it's not admissible because it was not part of their pleadings. Their lawyer may raise that matter before the court in address, but this cannot be part of their evidence.
Paragraph 7 or
6 and 7. Lords, we also take objection to that portion of paragraph 25, which starts on page 6 of their witness statement. Thus, the first respondent, in respect of the declaration of presidential election, betrayed the determination on the part of Mrs. Jean Adukwe Mensah as returning officer for the presidential election, and certain officials of first respondent to have second respondent installed as president of Ghana by hook or crook. My lords, we think that this is highly prejudicial and scandalous. There's no pleading that can support this type of scandalous and prejudicial piece of evidence, and we pray that it is struck out on those grounds. My Lord.
And Agutuampa.
Yes, ma'am.
So we are clear. Is it the sentence starting from page 5? In fact.
In fact, yes.
So it starts from page 5.
Yes,
and
you're right.
Ends at, yeah.
Page 2. Yes, it starts from page 5. Right. Relax. They're writing. My lords, our next objection relates to paragraph 26 from the sentence that reads, the chairperson of first respondent, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018, and with whose wife, Ms. Jean Adukwe Mensah, has a close familiar relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. My lords, we pray that this part of paragraph 26 be expunged as scandalous, prejudicial, and not based on the pleadings. These are very serious material allegations of fact, and they were not pleaded.
Yes.
Now the next part we take objection to relates to paragraph 28, which the portion reads, the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondent seeking to justify after the event Mrs. Jean Adukwe Mensah's 9 December 2020 purported declaration, and that undermines the whole attempt at correction of what was indisputably an error and in error-driven declaration, and shows, and my lord, that's a critical passage, shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast in the presidential election.
So does your objection start from the CPC or start from simply being?
It starts from shows, but you can only understand the shows if you relate to it to what comes before. But the specific objection relates to the showing that the figures were simply being cooked. My lords, we say that this portion of paragraph 28 is extremely prejudicial. No facts have been pleaded to that effect and ought to be struck out accordingly. My lord, paragraph 30 of the witness statement. My lord strangely seeks to suggest that the first respondent, because of his bias in favor of the second respondent, somehow.
Could you tell us what you're objecting to?
The basis.
The
whole of.
The whole of it. Yes, the whole of paragraph 30. My lord, it seeks to suggest that the new regulations were organized by the first respondent with the object of ensuring that the process of collation and aggregation of votes were introduced without any good reason. My lord is talking about a piece of legislation. My lord, it is the witness may not speak to the legal validity of a piece of...
Mr. Kutampo, so is it your objection that it's not based on pleadings, or that it unduly prejudices, or it's scandalous? You've told
My lord,
us
it's
three
not
grounds.
based on the pleadings, nor is it, and furthermore, it is unduly scandalous. And my lord, our next objection. No, I don't. Our next objection, my lords, relate to paragraph 32. My lords, this was not pleaded by the respondents, the petitioner, and my lord, it relates to 275 summary sheets results. My lord, nowhere in the petition has there been any reference to any 275 summary sheets. And the petitioner had all the opportunity to do so if he intended to rely on this evidence. In the trial. He failed to do so and is seeking, through his witness statement, to improperly introduce it through the back door. Should be, and we pray, therefore, that it be struck out. My lords, indeed, if your lordships take a look at the petitioner's amended petition, even exhibits were attached to the petition when they should not have been. And so they had every opportunity, even at the time of filing their petition, to follow that flawed tradition. But they didn't. And now, when they asked to write their witness statement, they introduced this huge piece of evidence which they hadn't pleaded. We ask that it be struck out as not based on the pleadings. And consequently, paragraph 33, which is a consequence of paragraph 32, should also, in similar fashion, be struck out. I hear you. My lords, as we've indicated, it is well established that a party's pleadings are fundamental in determining the case he or she intends to make during trial. The party's pleadings also notify the other side of the case that he will meet in court. My lords, the significance of pleadings have been set out very clearly in the case of Hammond and Odoi, 1982-83, 2 Ghana Law Report 215 at 1215 at 1235 to 1236. My lords, I know that this statement of the law is very well known to your lordships, so I will not detain you with reading it. My lords, I wish further to refer your lordships to the case of Adejumo versus Abegunde and another, reported in 1965 Ghana Law Reports 499, 1965, my lords, Ghana Law Report 499. which holds that in holding 1, well, now this is the Supreme Court, holding 1 to the effect, quote, although evidence is inadmissible to prove material facts which have not been pleaded, yet when such evidence is adduced at a trial without objection from counsel, the trial judge is bound to take it into consideration. My lords, we are making this objection so as not to fall into that trap. And my lords, we wish, in addition, to refer to the evidence decree. Where's the evidence decree? Evidence Act now, my lords, Evidence Act. Section 51, my lords, which reads as follows: for purposes of this decree, relevant evidence means evidence including evidence relevant to the credibility of a witness or hearsay declarant, which makes the existence or non-existence of any fact that is of consequence to the determination of the action more or less probable than it would be without it. And sub 2 reads, all relevant evidence is admissible except otherwise provided by any enactment. And sub 3 states, no evidence is admissible except relevant evidence. And my lords,
Section I'm not clear what lessons you want us to draw from
my lord, I'll shortly demonstrate if I'm permitted. Section 52B states the court in its discretion may exclude evidence, relevant evidence, if the probative value of the evidence is substantially outweighed by the risk that the admission of the evidence will create substantial danger of unfair prejudice or substantial danger of confusing the issues. Now, my lords, the relevance of this piece of these provisions of the Evidence Act is that they confirm the position that any evidence that will be led must be based on the pleadings and be related to an issue in dispute. And that pleadings, evidence that spring from nowhere surprises the other party, and where they do cause, where they provide a danger of substantial or unfair prejudice, may be disallowed by the court. And that is why we believe it is relevant. My Lord, it is for these reasons my Lord, with all due respect, my attention has been drawn to paragraph 37 also. Yes, the last of any paragraph, where the witness states, I quote, "This conduct of certain officials of first respondent in padding the votes of certain respondents is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of the first respondent to have second respondent unconstitutionally and unlawfully installed as president." My lords, this paragraph is extremely scandalous, and what makes it worse is that apart from the so-called 4,000 plus padding that they allege, and they have not provided any further evidence or made any further pleading, indicating that there's a well-hatched and sustained pattern of manufacturing numbers unrelated to the votes. There's nothing in either their petition or there's nothing in their petition to that effect. My lords, I think it is significant that whilst the petitioner has been making these really scandalous allegations, he has not provided one shred of evidence of his own tabulation of votes. Nothing throughout the petition, not even in the witness statement.
Mr. Kutuampa, you take advantage of that. Why are you worried?
No, my lord, I'm saying that to show how totally unacceptable paragraph 37 is, and it ought to be struck out.
Mr. Kutuampa,
yes.
Let me chip in. You see, the pleading is different from evidence.
Yes.
Pleadings can be struck out on the basis that it's scandalous. Yes. But this is evidence.
And my lord, if it cannot be struck out, it should not be admitted.
No, if a pleading is scandalous, yes, it is a basis for striking out.
Very well.
Yes, but the evidence is quite different from a pleading, except that the evidence takes its roots from the pleading.
Yes, my lord. And our case is that these pieces of evidence are not based on the pleadings.
No, but if you... Yes, you must know the basis of...
My lord, they are not based on the pleadings, and they should not be admissible. Being scandalous. My lord, we pray accordingly.
As to what is wrong with paragraph 6 and 7? Paragraph 6 and 7. Yes, what is wrong with that? This is a fact.
Look at it carefully.
Yes.
Yeah, what is wrong with that?
My lord, our view is that those two paragraphs are not matters for his evidence in chief.
They are not matters of for evidence in chief.
Yes.
No. So assuming we are doing oral trial and the witness is in the box, can't counsel ask him whether in the course of this trial he's filed notice to admit? Can't counsel ask him?
My lord.
Or whether in this trial he's filed interrogatories? Can he be asked?
My Lord, in the first place, we want to make the point that the witness is a witness. It's not a representative of the petitioner. He's a witness, my Lord. And if your lordships look at the witness statement, he doesn't indicate that he has a power of attorney and he's speaking on behalf of the petitioner. He is a simple witness of the petitioner.
To find out. When you led him, he said he was on behalf of the petitioner. So I was going to ask.
He's a witness. He's a witness.
He's a witness of the petitioner. Okay.
No, one statement. Yes, my Lord.
What is your view about this paragraph? Because my understanding of why we are here is that we are dealing with the validity of the election of the candidate. And when I look at the evidence, in 32 and 33, the witness just stated numbers, applications, 375 summary sheets, 30,000 and 30 million, 218, and left it at that. How would that affect your case? When there's issue, you see, we are not dealing with the High Court trial. We are not in the High Court. We are in the Supreme Court exercising a special jurisdiction over the validity of election of a candidate. So you have to limit everything, your submissions and your cross-examination, to the validity of the election of the candidate and not a general trial in the High Court. So you're complaining about 32, 33. How would that affect your case, the validity of the election of the candidate? Has the witness made any assertion that because of that, votes and other things and whatnot? So you look at it, if there's nothing, let the trial proceed. Otherwise, we'll be going through this banter and we'll spend the whole time raising objections and this and that. So let's focus on why we are here.
My Lord, that is precisely what I'm trying to do. My point, my Lord, is that the petitioner in his petition has never said anything about summary sheets. Indeed, the petitioner in his petition, in our view, has not challenged the validity of the election. It has simply picked on some errors in the announcements and the tabulation of the results. He has not provided...
And in these two paragraphs, 32 and 33, the witness is also not saying anything about the validity of the election.
Yes.
So why not keep quiet over it? That's what I've been telling my students in advocacy lectures.
Yes, my Lord, we will not keep quiet over it because it could be prejudicial. It may cast an unnecessary cloud over the elections. It is not being pleaded, and my lords, I believe that they cannot lead evidence that is contrary to their pleadings.
Thank you.
But I want to know whether Mr. Minuvo has something to say about the witness statement. Yes, Justin.
Yes, my Lord. My Lord, I have nothing more to add to what Mr. Akotwampa has said. Thank you.
I associate myself with his submissions.
My lords, we have to deal, I believe, with a very practical issue before I get into the responses. Quite a lot of objections have been raised, more than 10, I believe. If it were a trial in which oral testimony was being given, in evidence in chief, there would be a series of objections at different points, and then one could take it up. And the practical difficulty I'm talking about is that as he was raising the objections, we were busy trying to deal with it. And we're frankly not, I should speak for myself, I'm frankly not sure that I have listed all the objections.
Mr. Chikata can help you.
So,
Mr. Chikata, we can help you.
Yes, very
We captured them all.
Yes, very well. So what I was going to say, my lords, is that as we proceed with the responses, we may need to come back to your lordships for the statement that you have recorded in respect of the objections, so that the answers will be appropriate in terms of what your record shows. That's what I meant by the practical solution to ensuring that we are addressing all the objections. But we're ready to respond to each of the objections, and guided by your record of the objection.
It appears the first objection, I hope you recorded the basis for the objection.
As I said, we're trying hard to record it. But
No. I know that it's very difficult to get the very paragraphs he referred to. Yes, I'm talking of the grounds for the objections, which were what? That
oh yes,
it was not based on the pleadings.
The two grounds that he said at the beginning. Yes,
thank you. Yes, the first one was in respect of paragraph 21. Paragraph 21. Then the second, we went back to paragraph 6 and 7.
Yes.
Yes. Then he went to paragraph 25. Paragraph 26.
25,
the portion, not the whole.
From
the latter part of paragraph 25.
Yeah,
yes. Yes. Then he went to paragraph 26. Then went to paragraph 28, paragraph 30, paragraph 32, paragraph 33, paragraph 37. Yes. Then I think that is all.
That's all.
That is all. Please, yes. Can I go over?
I have the paragraphs, but as I go on, the particular ground that he gave for each paragraph, I may ask for
no problem. No problem.
Yes, I have the paragraphs all right. No, yeah. Now, my lord, the first paragraph, and my lord, I start off with the fairly elementary statement of the law that pleadings are not meant to be evidence. And my lords, Rule 7 of Order 11 makes clear that subject to this rule and Rules 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for a claim or defense, but not the evidence by which those facts are to be proved. And the statement shall be as brief as the nature of the case admits. Now, my lords, that's fairly elementary and well-known rule. And if we take the various objections, paragraph 21 is that, and paragraph 21 follows paragraph 20. So if I may first refer to paragraph 20. In this unsigned press release, first respondent introduced new figures for the total valid votes cast in the presidential election held on 7th December 2020. A copy of the said press release is attached and marked as Exhibit B and was available on first respondent's website, www.ec.gov.gh, as of 11:45 GMT on 29. So even as late as just before the petition was filed, we were pointing out that that document was available. And paragraph 21 is making reference to the fact that following that press release, the results being published by first respondent on this website became moving targets. Now that's evidence in respect of what happened to the numbers that were provided for in paragraph, that were mentioned, that were alluded to in paragraph 20. And becoming moving targets, subsequently deleted the changing figures from the website. That is material evidence that undermines the figures that were in that press release. Because there were figures in the press release, as we indicate, an unsigned press release that's, again, very clear. And subsequently, those were themselves being changed. I cannot see how this is immaterial. And my lords, particularly in a situation where the witness statement of the first respondent, that witness statement itself has different numbers from the numbers in the press release and the numbers in the declaration. My lords, I cannot, with the greatest respect, see how evidence about changing figures is not material in these proceedings.
Mr. Speaker, that is not the point. He said he says that this paragraph 21 has not been pleaded. It doesn't take its source from your pleadings. So perhaps if you look at your paragraph 28 and 29 of the petition,
yes,
you may be able to respond to it. The ground is that it has not been pleaded.
Let me just...
Yes, on the pleadings.
Yes.
If you look at your paragraph 28 and 29, yes, so look, so that you can help it.
My lords, indeed, in our paragraphs 28 and 29 and 30 of the pleadings, we state on 10th December 2020, an unsigned press release of first respondent claimed that its chairperson, Mrs. Jean Adukwe Mensah, had inadvertently, in quotation marks, used a figure of so-and-so. And then we continue in 29. In this purported corrective press release, first respondent introduced two completely new figures for the total votes cast in the presidential election. Thus, there was no correction properly so-called. Since to be valid, a correction of a prior mistake must correctly name the mistake to be corrected. In this case, the mistake to be corrected was itself mistakenly stated. The numbers so-and-so are completely different. And then paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. That is pleaded. And then it goes on in paragraph, it goes on paragraph 31. I'm sorry.
So go to paragraphs 6 and
Now, in paragraph 6 and 7, my lords, and your lordships will recall that in following your orders in terms of the filing of the witness statements, we actually drew attention to this issue of the request to admit facts, issues which normally would be part of the pretrial and which therefore affect how we prepare a witness for the trial. So, my lords, the point of paragraph 6 and 7 is precisely to indicate to your lordships the parameters within which his evidence is are being placed, because those parameters are.
We are worried because Mr. Esiedu Nketia is not the petitioner. He's not a party, strictly speaking. He's just a witness, as you rightly pointed out. So let's look at it in that.
Yes, but my lords, he is a witness of the petitioner, and as a witness of the petitioner,
He can smack everything in the proceedings.
he can, yes, he can, my lords,
as a witness,
he can swear to matters that are within his personal knowledge. And those matters include processes which he is aware of. I mean, those processes are, in fact, a matter of public record, literally.
Because, you see, we don't want, sir, we don't want a situation where, under cross-examination, a question is put to him. Do you know anything about notice to admit?
My lords,
No, the situation can arise because, you see here, he is or not.
my lords, he
He's or not.
oath, and I'm sure that he will be able to take care of himself on oath.
No, we want to avoid a situation where maybe.
No, my lords, with respect,
We just want to streamline the way things should be done.
yes, and my lords, respectfully, my lords, that's why I respectfully.
Let's move on. Please, let's move on.
in fact,
Yes. In the box, we wouldn't have placed it.
Well, my lords, frankly, there is no difference in terms of these particular paragraphs, because the petitioner is not himself the lawyer filing those processes. The petitioner, yes, but the petitioner gives the instruction, and a witness of the petitioner, who is as aware as anybody else of those processes, can speak to those processes, because he's a witness of the petitioner. And as a witness of the petitioner, he familiarizes himself with processes that are filed. And in fact, more importantly, as a witness, and the point of those paragraphs is very clear, as a witness, he is indicating to the Honorable Court that I'm aware of these, and that is guiding what I have to put in my witness statement. That is part of the point. And my lord, and that is why, in fact, before he went into a witness box, I did draw your lordship's attention respectfully to the fact that we wanted guidance on whether we needed leave subsequently after those issues are resolved with the search that we're making. And your lordship said he should go into the witness box. So my lords, I have no doubt that the witness is able to address those issues in terms of his knowledge of the facts of what has been done on behalf of the petitioner. I have no doubt about that. In respect of paragraph 25, in respect of paragraph 25, and again, paragraph 25 can only be read in conjunction with the prior paragraph. In announcing the various so-called corrections and corrections of corrections, no officer or first respondent engaged in any consultative process involving petitioner or his accredited agents, nor did Mrs. Jinadukwe Mensah, returning officer for the presidential election, or first respondent notify petitioner or his agents that there was a reasonable basis to revise the figures as to the votes he, petitioner, and or second respondent obtained, much less give them an opportunity to observe or participate in the processes by which those revisions were purportedly effected. That is 24, to which no objection is raised. Then in 25, it goes on this, referring back to what has just gone on. This was clearly contrary to the responsibilities the chairperson of the first respondent and first respondent as a whole had by virtue of Article 23 of the Constitution, which provides that, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal, unquote. In fact, the ever-changing figures put out in the unsigned press release and what was posted on the website of the first respondent in respect of the declaration of the presidential election betrayed the determination on the part of Mrs. Jinadukwe Mensah as returning officer for the presidential election and certain official or first respondent to have second respondent installed as president of Ghana on 7th January 2021 by hook or by crook. Now, my lords, in the pleadings, in paragraph 33, my lords, in fact, if I may start actually from paragraph 20 of the pleadings. I may even start from 19, because in 19 is the statement, first respondent and his chairperson, Mrs. Jinadukwe Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Paragraph 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Jinadukwe Mensah, acted in flagrant violation of the 1992 Constitution.
Mr. Chikata,
Mr.
Chikata,
yes.
Could you hurry to where it is your pleading that she intended to install the second respondent by hook or crook, or where this evidence takes its roots from?
In paragraph 21, we say that first respondent, she was required to act fairly, reasonably, candidly, and not arbitrarily or capriciously. And then we go on in paragraph 24. We go on to point out that she was required not to be biased, either by resentment, prejudice, or personal dislike, and also requires them to exercise discretionary power in accordance with due process of law. So we are pleading the fact that these were requirements placed on her and evidence to show that she did not comply with those requirements is certainly available on the basis of those pleadings. And as I indicated, in relation to
law, and you then go on to draw the conclusion or to conjecture that she was determined to declare the second respondent as president by hook or crook.
My Lord, that is
just
my Lord, that's not a conjecture. That's not a conjecture. If they want further and better particulars of it, of course they're entitled to ask for further and better. But it is not a conjecture. And we are saying that these are matters that are demonstrated in the various pieces of evidence, especially relating to ever-changing numbers on the website that will obviously be before you. And in fact, most of these are not denied. It's not denied that there were changes and ever-changing figures. It's not denied that, you know, what is in the answer, the figures in the answer are different from every other figure that we've seen in these proceedings. Now, my Lord, we are saying that all this is evidence of a predetermined agenda. That is, you know, my Lords, in proving facts, in proving...
This is really what I wanted you to show, that the statement or the pleading that there was a predetermined agenda to end in a particular way. That's what I'm trying to find from your...
That is a necessary implication from the ever-changing figures that were supplied right up until the point of the answer. And my Lord, that is a matter that circumstantial evidence is obviously permissible in proving facts. So
hold on, say. So your response is that this allegation of hook or crook is actually intended to lead us to a conclusion that is made out of inference. Is that what you're saying?
It's based out of the circumstantial evidence, the compelling circumstantial evidence.
It's an inference. It's an inference that you are making. And you know, inferences are alien.
Yes.
In evidence. You can be an address, but not evidence.
Yes, my Lords, I said we are giving circumstantial evidence on the basis of which conclusions.
What you are describing as circumstantial evidence is an inference. You are making an inference. And evidence, we don't do inferences.
My Lord,
you can address on it.
My Lord, these are not inferences. We are saying there was a predetermined agenda, and we're saying that that predetermined agenda is evident from the ever-changing circumstances and from the refusal to act in accordance with the responsibilities to be fair and candid. We say in paragraph 22 that she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. We say in paragraph 23 that prior to her making the said purported declaration, Mrs. Gina Dukwemesa had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of these concerns. My Lord, if evidence cannot be given in relation to all these matters and how they lead to the inevitable conclusion of a predetermined agenda, then respectfully, I don't know what else we're supposed to do in terms of providing evidence. We go on. My Lords, I'm not finished. We go on in paragraph 30. In paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast
for various candidates are made without any explanation and with a total lack of transparency. My Lord, I mean, one should, with respect, I mean, take cognizance of the various elements of our paragraphs in the pleadings. The fact that there's no explanation, there's a total lack of transparency, these are all things that have been pleaded. And if evidence is being led in terms of the predetermined agenda and the determination by hook or by crook to arrive at a certain result, I cannot see how that evidence can be regarded as objectionable in any way. They can cross-examine on that evidence. They can seek to discredit him and say that he has no basis and whatever. But we cannot say that that evidence is not admissible. Now, my lords, I believe the next paragraph was paragraph 26. The Gazette notice is required to be based on the declaration actually made by Mrs. Jean Adukwe-Mensah as the chairperson of the first respondent. I'm sorry, that's our pleading. 26 of the witness statement. Yes. The 26 of the witness statement is where the chairperson of first respondent and first respondent are also not required under Article 296 of the Constitution to be biased either by resentment, prejudice, or personal dislike in exercising any discretionary power. They're required to exercise such powers in accordance with due process of law. The chairperson of first respondent, Mrs. Jean Adukwe-Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018, and with whose wife, Mrs. Jean Adukwe-Mensah, has a close familial relationship. Mrs. Mensah was thus at all times, at all material times in the conduct of her responsibilities, biased by prejudice in favor of the second respondent. Now, my lords, we have again pleaded the requirement of compliance with Article 296B. And in turn, in their answer, paragraph 39, paragraph 40 of their answer. In further denial of the petitioner's claims, first defendant says that it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias against anyone. So there's a denial of our allegation. There's a denial of that. And therefore, a witness that is speak she actually goes on in paragraph, the answer goes on in paragraph 41 to talk about, in a bid to enhance transparency and public participation, it took certain steps. So, my lord, clearly the answer of the first respondent shows her recognition that the issue of her bias is part of what has been pleaded. And she is asserting in paragraph 40 that she did a first respondent, well, in fact, respectfully, that paragraph just says the first respondent. It doesn't speak specifically about her. So we should take the words as they are. The first respondent says it's complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election, with fairness to every candidate and without malice, ill will, or bias. So clearly, there is an issue that is before this court of whether there is bias to anyone or in favor of anyone or not. There is an issue.
So, Mr. Secretary, where in your pleadings did you plead that there's bias because the first respondent, in a way, is related to the wife of the second respondent? Where?
My lords, we plead the 296B, bias by either by resentment, prejudice, or personal dislike.
Honestly, by the use of pleadings, we don't plead law. We don't. 296 is a constitutional provision.
Yes, my lord, we plead law in the context where certain facts related to the operation of that law are being contested, because we have to state that the Constitution has this requirement in order to point out that that requirement has not.
But then they went further, as you rightly pointed out in, I think, was it paragraph 40? Yes. And then they pleaded in answer that they complied with the law and that they were not biased, and they went through with the due process as required by law.
So
yes, but then if you go further and we are concerned with the last paragraph of paragraph 26. We are not comfortable with it.
That is their problem.
That is their problem.
The paragraph starting from the chairperson or first responder, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of the second responder, who appointed her in August 2018.
Yeah, that is...
And with whose wife, Mrs. Jane Adukwe Mensah, has a close familiar relationship. Mrs. Mensah was thus, at all material terms in the conduct of her responsibility, biased by prejudice in favor of the second respondent and against the petitioner. They are saying that this has not been pleaded, this fact, this evidence is not based on the pleadings.
We are saying respectfully that what is contained in the witness statement is evidence of the pleading of non-compliance with Article 296B, because that is part of our case.
No, but you must plead before. I mean, the thing does not even appear in your pleadings. So how can it turn to become evidence? The thing does not appear in your pleading. We have not read anything like this from your pleadings, from the petition.
Don't you think the close familiar relationship should be a material fact that based on Order 11, Rule 7, you should include in your pleadings?
My lords, I am not of the view that by itself is a material fact that should be reflected. And my lord, let me be clear. Bias could be related to a number of different factors. A close familiar relationship is a potential element. And if, in spite of the close familiar relationship, there is action taken that reflects due process, transparency, and everything, then in that situation, the close familial relationship would not affect the conduct of the proceeding. So it is really a matter of evidence whether in the context, in the circumstances that we're dealing with here, whether we have a situation in which that familial relationship has actually affected the conduct of the responsibility. That is a matter of evidence.
How does she respond to this? This is your evidence.
To that.
This was not in your pleadings. This was not in your pleadings. Are you not taking her by surprise?
Well, we don't believe that this takes her by surprise, because this, I'm sure, is
legally.
There are facts that are very well known to her. In fact, there are facts that are...
But we don't know. Well, we're sitting here, we don't know. Until we read this, we didn't know.
Okay.
Okay.
My lords, we are saying that in respect of paragraph 26,
Can I find
I'm concluding my response on paragraph 26. Am I allowed to do that? We're saying that in response to paragraph 26, these allegations of bias are sufficiently referenced in our pleadings in relation to the operation of Article 296B. And we're saying that the denial that is contained in paragraph 40, that denial indicates that the petitioner is not taking the first respondent by surprise in respect of the allegations of bias that are in the witness statement. Now, that's in paragraph 28. I understand that the objection is to a portion of that paragraph, and if your lordships could clarify which portion. Yes, the secrecy and lack of transparency regarding the figures thrown up by one or more officials or first respondents seeking to justify after the event, Mrs. Jinadikwe Mensah's 9th December 2020 purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration and shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast. My lords, I have referred already to our pleadings in respect of transparency, and I have also referred to our pleadings in respect of these changing figures. And if I may go over that again for the purposes of this response. And we start from paragraph 8. The claim that the percentage of votes obtained, paragraph 8 of the amended petition. With the claim that the percentage of votes obtained by second respondent was 51.595 of the total valid votes that she herself distinctly stated to have been 13,434,574 was a manifest error, as votes cast for second respondent would amount to 50.098 and not the 51.595% erroneously declared. And then in paragraph 12, which I referred to before, we indicate that if the total number of votes standing to the names of each of the presidential candidates is summed up, this would yield a total number of valid votes cast of 113,121,111, a figure that is completely missing from the purported declaration by Mrs. Jinadikwe Mensah on 9th December 2020 and the purported rectification on 10th December. So we have already intimated these initial changes. And then we proceed, as I indicated previously, we proceed to make reference to the fact that this is in paragraph 22, which I referred to before. Mrs. Jean Adukwe-Mensah predetermined prior to the 7th December 2020 presidential and parliamentary elections that she would announce the results within 24 hours after the close of polls. Consequently, she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. Prior to her making the said purported declaration, Mrs. Jean Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of those concerns, and the letter is attached. And then we also further indicate the lack of transparency that was involved in the purported corrective press release. And this we do in paragraph 30, in seeking to justify the new figures put forward in the press release. Various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. There's a direct reference to the lack of transparency in that paragraph. And we go on further in paragraph 31 to say that the so-called rectification of the errors in the purported declaration was itself egregiously wrong, and we go on to provide. So, my lords, in paragraph 33, if Mrs. Jean Adukwe-Mensah, as returning officer of the presidential election, had determined in good faith that her declaration on 9th December 2020 was in error, her constitutional duty to be fair and candid, and my lord, that explains why we had reference to the constitutional duty in the pleadings. That her constitutional duty was to be fair and candid required her, among other things, to acknowledge the error, set aside her erroneous declaration, and proceed on the path to correcting her error, respecting the rights of candidates to participate in the processes towards the making of such a declaration. So we indicate what transparency required. We didn't just say lack of transparency at large. And we go on in paragraph 34 to say that the unsigned press release of first respondent has no value in the determination of the validity of the declaration that Mrs. Jean Adukwe-Mensah made on 9th December 2020, especially as the issue of the release was not undertaken transparently and in accordance with due process of law and established practice, including the participation of affected candidates through their respective agents. So we have pleaded everything that we need as a foundation for pointing out that what was done secretly, in the sense that it was done, you know, without reference to any of these candidates, completely by themselves, and not in accordance with the legal requirements for the participation of agents of the candidates. I mean, all these paragraphs that I've adverted to are specific in reference to lack of transparency, lack of contact, consultation with anybody. And my lords, I mean, I cannot see how the witnesses' indication, the indication that the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondents seeking to justify after the event Mrs. Jean Adukwe-Mensah's 9th December purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various elections, so for the various candidates. So, my lord, the point we are making is that there has been sufficient basis laid in the pleadings for there to be evidence that shows that figures were just being cooked, because the figures are coming out of nowhere and without reference to anything that is transparently communicated to anybody. My Lord, with the greatest respect, I find it very difficult to see how any objective observer of the ever-changing figures that have been put forward can fail to see that we are not justified in talking about figures being cooked. And my Lord, figures being cooked is simply an indication that the figures are, just being thrown up, unrelated to valid votes being cast, counted, and collated, which is what it should be. So, my Lord, respectfully, we would submit that there is a basis in our pleadings about lack of transparency, lack of due process, in respect of paragraph 30, and if your lordships could again perhaps read out what the ground, the specific ground is, so that...
Are you asking for help with paragraph 30?
Yes.
30, the whole, 30, the whole of the paragraph.
Yeah.
On the basis that...
Yeah.
On the basis that the witness cannot speak to the legal validity of the legislation referred to, that is CI
127. Mm-hmm.
Okay, my lords, this again is not a pleading of law at all. This pleading states in the new regulations promulgated, and it's not an issue about the validity of the constitutional instrument. That is not the issue. In the new regulations, this is just a factual statement about how the new regulations operated. In the new regulations promulgated by first respondent, CI 127, it now interposed between the strong room and the constituency collation centers without any good reason another layer of collation at its regional offices with regional summary sheets. That is a fact. It did that as a result of the constitutional instrument. This led to results being sent from regional collation centers which were at variance with the results collated at constituency collation centers as a result of figures being altered by officials of first respondent. Exhibit C provides sample details of wrong aggregation of valid votes on the face of the summary sheets of some 11 constituencies. The exhibit shows that the sum total of valid votes obtained by all candidates varies from the figure recorded on the face of the summary sheets as the total valid votes from each of these constituencies. Now, my lords, the statement there is quite clear about the interposition of the regional collation centers as a source of errors. And an exhibit, Exhibit C, is also provided. In the petition with the sample details. Now, my lords, it needs to be clear. It needs to be clear that in this petition, unlike perhaps in the 2012-2013 petition, the petitioner did not come to court saying that, and now 4 million votes of voters who have voted. And now then, because in some cases pink sheets didn't have presiding officer signature, or there were duplicate serial numbers, that in the nature of this petition, the petitioner is saying that a certain declaration was made on the 9th of December. It was publicly made, we all heard it, and the petitioner is saying that when you look at figures in that declaration itself, those figures do not amount to compliance with a constitutional provision duly. That's what the now, in this paragraph 30, what the petitioner is seeking to do is precisely to provide, as it is said, a sample of wrong aggregation, and the petitioner is attributing that to the interposition of the regional collation center. So that is the import of that paragraph, and that import is related to the lack of transparency pleadings that we clearly have.
Mr. Chikata,
yes.
Your pleading indicates that that interposition comes from the new regulation, from the law. Isn't that your pleading?
The new regulation is, I didn't hear the last bit of
the testimony of the witness is that the interposition, the
new regulation
interposed, yes.
Yes.
And that's the source of the trouble. That's the source of the complaint.
Yes, in its operation, the way it operated, the way this new regulation was operated in practice.
And the objection is, the objection is that it seems to suggest that the new regulation of first respondent was about ensuring that the process of collation and aggregation of votes were introduced without good reason. And yet that was introduced through a law. It was a law that provided that framework. And
yes,
that is the complaint.
It was subsidiary legislation made by the first respondent, and the witness statement is indicating that the operation of that, it was a matter of law, but you can operate a legal provision in a manner that leads to wrong results. That's what we're saying. I mean, you could operate the creation of regional centers in a transparent way, which does not lead to the results.
And so once again, you are inviting us to make an inference, or what?
My lords, I'm not inviting just making an inference. I'm saying that we have pleaded a lack of transparency. We have pleaded a lack of consultation in respect of how these figures popped up. And the witness statement is showing one of the ways in which that lack of transparency was demonstrated in the actual conduct of the first respondent. That is what the witness statement is seeking to do as a matter of evidence.
But Mr. Chikat, there is nothing in the petition about this, let me call them collation issues. There's nothing in the petition that the collation process resulted in changed figures or figures changing.
We have pleaded the fact that numbers were being changed by the first respondent without any transparency.
Now, those numbers, is such a big issue that if that is your case. It should be in the petition that A, B, C, D, from this polling station to this constituency to this regional collation center, these figures changed. There's nothing about this in the petition.
My lords, the petitioner is not the returning officer for the presidential election.
Oh, but he's the one challenging
the petitioner. May I answer you? The petitioner is challenging, firstly, on the basis that you made a declaration in which you put forward certain numbers. On the face of your declaration, those numbers do not warrant your exercising your constitutional responsibility the way you did. That is a basic point of the petition. My lords, if I may finish my answer, because I believe it's important for the answer in its fullness to be heard. That the petitioner makes clear that her challenge is based on the fact that the person who is a returning officer, that person has purportedly made a certain declaration of someone as having won the election. And yet the figures that she has put in as the basis of her declaration, those figures do not warrant her declaration. That is the heart of this matter. Now, my lords, at the heart of that petition is this issue about the numbers that were acted upon by the first respondent. First respondent puts forward an answer in which effectively first respondent says, I am actually admitting that there were errors. That's what first respondent is saying. First respondent is saying, I'm admitting there were errors, but one, they were inadvertent. And they were corrected by a press release on the 10th of December 2020. We point out that the so-called correction itself contained mistaken figures. We point that out very clearly. And we further point out that those figures kept changing right up until the point where we have in the witness
my lords,
statement.
with respect, counsel has been repeating the same things for the past 15 or 20 minutes. It's the same thing he's been repeating.
My lords, I don't know whether that's meant to throw me off the course of my argument, but I think with respect, this is intolerable with respect, because I was in the middle of a sentence actually, and you know, it is not appropriate, you know, to make this kind of interjection.
Yeah, please, when you want to raise an objection, it has to be timeously raised. Yeah, so that, yes, you don't disrupt.
My lord, I thought I was actually raising it timeously.
My lords, I believe I was in the process of explaining that at the heart of the petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from those figures. And we're saying that after, we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you are supposed to be speaking to paragraph 30, which is about the original, the collation. And the question from my brother on my right was that There is nothing in your pleadings about the collation process.
My lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through, these 4 stages, and so she is in effect explaining herself in terms of her conduct, and we are saying that on that basis, the witness is entitled, because my lord, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead him and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? My lord, that's perfectly legitimate if I were leading him in the normal course.
Counsel, in fact, with the greatest respect, my problem is this. In the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127, the law that regulated election.
And the petitioner does not seek to raise an issue about the lawfulness
but by paragraph 30 of the witness statement, the witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that regional collation center.
So, my lord, you see, that were the provisions in CI 120. That was the regulations that regulated or governed the elections, the conduct of the election. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how there have been changes, now strong room to consensus collation. That's what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in your evidence, you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or raise an issue with CI 127. And we're saying that that is not the objective. But CI 127 has to be executed. And if the petitioner, in making this interposition without good reason, if the petitioner has, as a result, had problems in the collation, which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outline in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 5.
No, Mr. Chikita, we don't want you to read that one. We are familiar with that.
So, my lords, if I could, in oral testimony, leading him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent, which says they went in accordance with this and this and this and that? My lord, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist, and your lordships can correct me, if he were being led in the witness box in oral evidence, would I not be able to put the case of the first respondent to him? I could.
You could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Chikata, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming?
Yeah, blame, B-L-A-M-E.
But
blame.
My lord,
is it Parliament or the first respondent or the structure that was
my lord, frankly, Parliament has nothing to do with this.
Yeah, because what he did...
Parliament has nothing to do with it because this is subsidiary legislation.
But it was laid before Parliament.
Yes, but I mean,
it was laid before Parliament for 21 days.
My lords, anyway, my lords, I believe that is really not the essence of, because it
totally is. It's the essence.
So is Parliament responsible for all subsidiary legislation laid before them?
No, that's money.
Please.
The testimony, as far as I understand it, you are blaming CI 127 on her, because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we're saying that the implementation of the law is what occasioned the problems. And that this interposition without good reason was the opportunity for that really error-ridden implementation to take place. That is what we're saying.
But the problem is with the implementation of the law. Then, in essence, the first defendant, the first respondent, did violate the law. But you've not indicated anywhere.
Necessarily, you don't have to violate a law in order to implement it in a way that occasions...
If you don't implement it correctly, as provided in the law, then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of a law or of a statute, a piece of subsidiary legislation that she introduced without good reason, we're saying that that was a part of the problem. And we've given a sample of why that occasioned the problem. In paragraph 32, indeed, aggregating the votes, yes, my lords, aggregating the total valid votes as shown by the 275 sum sheet released by the first respondent on his website, the resultant figure is actually 13,200, which is different from the 9. I mean, my lords, how can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she herself, or figures that her first respondent has put forward as a correction of other figures that she read, which we all heard. She's put forward those figures. And here, and then subsequent to that, there is published on the website, 275 constituencies. And we do our arithmetic and we say that those figures actually result in this, not in the figure of the purported correction. How could that possibly not be, you know, I mean, a piece of material evidence from a witness in this election petition, aggregating the total figures. And my lord, this comes directly following paragraph 31, after the 7th December 2020 presidential election. Petitioners, paragraph 31 of the witness statement, petitioners' representatives in the strong room discovered that there were errors, as a result of which they did not certify the summary of the results from some of the regions. They also noticed anomalies with some of the collation sheets that may have been inputted into the results. Based on the observations, the NDC calls a letter and so on. And then indeed, and it follows by talking about what the first respondent put on the website, which is in contradiction to what she purported to be the correct figures. I mean, my lords, and what is more, those figures are different from
really, they are not making any case against paragraph 31. Yeah.
Yes, but paragraph 32.
It's 32.
Paragraph 32.
They are not quarreling with
paragraph 32 is stating quite clearly that the figures that were published by the first respondent on their website, when you put them together, and this again is a matter relevant to the different figures that were being offered by way of correction on the 10th and later. So I think this is a very material, you know, every piece of evidence, especially, my lords, when it is acknowledged that the witness can have put to him the case of the first respondent. The case of the first respondent is that an inadvertent error was made and it was corrected. And the correction itself was subsequently corrected. And we're saying that when you take what is on their own website, this is effectively in the nature of an admission by them that they were wrong even in their purported correction. This is a clearly material piece of evidence. And in paragraph 33, which is the last, I think the last but one, again, this is a statement of that point, that the aggregated figure from the total valid votes as shown by the 275 summary sheets released by first respondent on his website. This figure is also different from the corrected figure of 10th December in the unsigned press release. So paragraph 32 makes reference to the figures on the website, and then paragraph 33 says that that was also different from the corrected figures. And my lords, with the greatest respect, the issue that is at stake in this petition is the conduct of the first respondent as the returning officer of the presidential election. And that conduct...
Mr. Chikata, which relief relates to the conduct? If we look, which relief? For settlement. You're seeking declaration.
The issue that we've put down, the relief that we have put down is a relief. We have put down a number of reliefs. Now, relief A is that the chairperson was in breach of Article 63(2). Relief B, a declaration are based on the data in the declaration made, the data contained in the declaration made by Mrs. Jean Adukwe-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7th December. No candidate satisfied the requirement of Article 63. The third relief is a declaration that the purported declaration made on 9th December of the results of the presidential election by Mrs. Jean Adukwe-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7th December is unconstitutional, null and void, and of no effect whatsoever. Now, I mean, we have set out in the preceding pleadings the basis of our claim of unconstitutionality. We've set them out, including the failures in respect of Article 23 and the failures in respect of Article 296. We've set them out. And we're saying that
thank you.
A declaration that is unconstitutional should be made. And in paragraphs 32 to 33 of the witness statement, we are responding, as we're entitled to, we're responding to the case that the first respondent is putting forward, in which she puts forward certain numbers, and we are relating those numbers to what she herself had, or what the first respondent had put on their website. And with the greatest respect, that is clearly a relevant matter. Now, my lords, I have to say that, I mean, these attempts to, take out of our witness statement extremely material matters that relate to the case that is being presented by the first respondent, I mean, are really matters that we consider, really very, very seriously, because we cannot see how anyone can objectively claim that these changing figures that we have been talking about as part of the lack of transparency and so on cannot be accepted as part of the witness's witness. Paragraph 37, this conduct of certain officials, and maybe, again, my lords, paragraph 37 cannot be read in isolation of the previous paragraph, because when it says this conduct, the meaning of this conduct cannot be read without going back to 36. In 36, because 36 says, Exhibit F is a spreadsheet covering sample details from 26 constituencies showing vote padding by certain officials of first respondent in favor of second respondent. When the votes second respondent obtained in all polling stations are shown on their respective pink sheets in these 26 constituencies are aggregated, the resultant figure differs from the figure that was declared by first respondent for second respondent as captured on the summary sheets of the respective constituencies. They show that more votes were added to those of second respondent than he had in fact obtained. So this is a conduct that is then referred to at the beginning of 37. This conduct of certain officials of first respondent in padding the votes of first respondent is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers, with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of first respondent to have second respondent unconstitutionally and unlawfully installed as president of Ghana. So this again is evidence that concludes paragraph 36, and paragraph 36 is not being objected to, and it concludes paragraph 36 and indicates that this conduct that is referred to is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers. And my lords, whether indeed numbers were being manufactured or not is obviously a question of fact. It's an issue that is to be resolved by the evidence of the parties and by the determination of which evidence is worthy of acceptance as truthful evidence. And therefore we submit that none of these passages of evidence can be considered as passages that cannot be legitimately within the witness statement of our witness.
With the leave of your lordships, we wish to refer to Order 11 to reply. Yes. Yeah. May I have the lead of the court to reply? My lords, I wish to refer to Order 11, Rule 12.1 of CI 47, which reads, and I quote, subject to sub-rule 2, every pleading shall contain the necessary particulars of any claim, defense, or other matter pleaded, including, but without prejudice to the generality of the foregoing words. A, particulars of any misrepresentation, fraud, breach of trust, willful default, or undue influence on which the party pleading relies. And B, where a party pleading alleges any condition of the mind of any person, whether of any disorder or disability of mind, or malice, or any malice, fraudulent intention, or other condition of the mind, and except knowledge of particulars of fact on which the party relies. My Lord.
Mr. Kutuampa, what you've just read is for the practice and procedure in the High Courts.
Yes.
Yes, and that's not what is before us is not pleadings properly so-called. Yes. This is an election petition.
Yes.
And it's regulated by rules and other things. So we have made it clear that we are not applying the High Court Civil Procedure rules in this case. We are applying the Evidence Act to regulate the taking and admissibility of evidence in this case. So allow us to regulate the procedure, because this is an election petition, because it appears it's something new. So the lawyers keep on referring us to the High Court Civil Procedure rules and other things. But this is a peculiar jurisdiction which we are exercising.
No. My Lord, my understanding is that these rules may provide guidance to the court, and it is part of our legal practice, but where a party alleges matters relating to a state of mind, like predetermined mind and prejudice and so on, he must give particulars in his petition. The petitioner never gave the particulars relating to the alleged predetermined intention, the bias, and so on. None of these matters, particulars, have been pleaded. And we would urge, based on that and all the other things we have submitted to this honorable court, that the pleadings, the evidence, the paragraphs in the evidence, many of which are actually material facts which ought to have been pleaded, should not be admitted. We pray accordingly.
Respectfully seek your permission, because a point of law, a new point of law has been raised. Because as the law is that well, very well.
All rise.
That's my friend over there. Hey, Asoto!